Matthew Rambo presiding.
Thank you. Please be seated. On the record, August 5th, 2026, case of State of Ohio versus Stephen Anthony Kurzinger, case number 25C000064. Mr. Kurzinger is present in the courtroom from the Geauga County Jail with his attorney, Matthew Bangerter. State of Ohio represented by Assistant Prosecuting Attorney Nicholas Burling and Prosecuting Attorney James Flays. Mr. Kurzinger, you previously entered a guilty plea to count one of the indictment, aggravated murder, and unclassified felony. A PSI was prepared, and today we are here for sentencing. Mr. Bangerter did file a sentencing memo yesterday, I think. The state of Ohio did not file a sentencing memo, but was not required to do so. Counsel, any additions, amendments, errors in the PSI that need to be corrected?
No, Your Honor.
Mr. Burling?
No, Your Honor.
I know we've got a full courtroom, so anybody that's going to speak clearly and loudly so the court reporter can take down your testimony or whatever you're going to say. And Mr. Bangerter, the floor is yours whenever you're ready.
Your Honor, we'd ask to reserve our comments for after the state's presentation.
Okay. You don't want to speak at all?
I prefer to wait till after the
Mr. Burling?
Thank you, Your Honor. Your Honor, at this time, we do have 3 representatives of the victims who are going to be speaking, so I'll have you guys step forward. And if you could just, when you speak, if you can give your name for the record.
I would ask anybody that's going to come forward and speak to speak at the podium, please, and direct your comments towards me, not anybody else that may or may not be in the courtroom, okay?
Okay. Hi, my name is Marie Ann Brown. Do I just start reading?
If you're going to read, make sure you read slowly. The court reporter is taking everything down.
Okay. When I think about what you did, I wonder how can you go from loving someone so deeply that you would do anything to be with them, rooting for them to do better, and then brutally killing them? I've never hated anyone as much as I hate you, Steve. I never knew this kind of hate even existed. How dare you take Alex away from me, from her kids? How dare you take her chance to live a better life away? You left her in her darkest days, and then when she finally found the light without you, you had to snuff it out. You took your own children's mother away. They will never get the chance to see her at her best. They won't have her at their wedding or introduce her to their kids because of your selfishness. That's all she lived for, was to be a better mom. And you took that away from them. You took my best friend away, the one who taught me it was okay to be different and introduced me to the weird, fun part of life. Alex accepted everyone for who they were and always saw the best in you. Her laugh made the whole room laugh. She was never perfect, but you took her ability to better herself away further from her. As I look at you sitting there, I feel pity. Pity that your life got so low that you had to kill her to win. I hope you sit in your jail cell and remember the light force Alex was when you fell in love with her, and how you took the light from her eyes in 1 second of evil selfishness. I hope she haunts you in your dreams and in your daily thoughts, because in reality, Alex won. She made herself better. That's something you could never do. You might have taken her body, but her soul will live on in all of us, remembering the light she brought to this world. Thank you.
Thank you.
My name's Rachel. Me and Alex are first cousins. We were the first granddaughters. We were each other's first best friends. And you know, Steve, there was a point in time where I actually rooted for you. I thought finally you guys could get better by being separated and actually become sober and decent, better parents and learn to co-parent together for the betterment of your own children. But it's very evident as we all stand here today that she was the only one that could actually do anything to better her life. How is it that this could start off so amicably and result in murder? You're not a hero. You didn't do anything great for anybody. You just added to the long list of trauma that was already a result of your guys' marriage. And instead of trying to be a decent man and father, you chose to act like a child who couldn't take no for an answer. You're nothing but a coward, a little boy who refused to learn to regulate and accept responsibility, nor learn to take accountability. A child who needed a constant bailout for either my grandparents or your own parents. All anybody ever wanted was for her to get her life together and be better, and you murdered her for it. You're disgusting. And I hope you rot. Thank you.
Thank you.
Might be a little redundant, sir. This begins and ends with you, Steve. You took vows of marriage before God. You went to Catholic school. You know who God is. As a husband, father, leader of your household, that is where it begins. No discipline, no structures, no jobs. Drugs, alcohol, chaos. From day one, 15 years ago. And she stood right with you. Right with you. You guys get divorced and all of a sudden she's the devil? She capitalized on that. She has been sober since 2021. I'm sorry. She got her life together. She was sober, living on her own, had a house big enough for visitation, had a job, was not barricaded in a free home lying in their own excrement, spending the child support money that your kids did not get. Those were you. At what point is doing what the law asks you to do, receiving your recovery, working a program, at what point do you get punished for that? I have my own history and my own crimes that I have to answer for. Christianity says that I have to forgive you, but today is not that day. This is an escape, if you ask me, Your Honor. This is just an escape. He created the amusement park and decided to kill somebody when he wanted off the ride. You can scream martyr, but you're a coward. You still get out of taking your responsibilities. You're off the hook. Everyone else around you, your family, everyone, countless people hang because you didn't want to be a man. You. I mean, at this point, you have breath in your lungs. You're welcome.
Thank you. Mr. Berlin?
Thank you, Your Honor. Your Honor, at this time, I know the court has the pre-sentence investigation that gives a summary of the case, but what we would like to do is walk the court through in a little more detail the investigation and some of the evidence that was collected. So at this time, I would like to call to the stand Lieutenant Delisa.
Okay. Lieutenant, come approach. You're not going to be placed under oath. This is not an evidentiary hearing. And I'm going to let Mr. Berlin kind of lead you through your testimony. Again, I'm sure you've testified before. Make sure whatever you say is clear and loud and into the microphone. And my court reporter has a more difficult time seeing you, so make sure that we proceed accordingly.
Okay.
Go ahead, Mr. Berlin.
Your Honor, if you could also share the screen so I could put some things up there.
Hopefully I can. You want the full screen?
Yes, if you could.
There you go.
Okay, thank you, Your Honor. Good morning, Lieutenant. Could you just state your name and spell your name for the record?
Matthew Delisa, Delisa.
Okay, and you work at Chardon Police Department, right?
I do.
What is your rank?
I'm a lieutenant.
And so what are your everyday duties and responsibilities as lieutenant?
I do oversee the daily responsibilities and duties of the officers, reviewing reports, arrests, citations, their investigations. I do overview and supervise all the criminal investigations with the Chardon Police Department, along with my administrative duties, scheduling, things to that effect.
Did you ever take part in the investigations themselves as well?
Yes, I do.
Okay. So are you familiar with the investigation into the murder that we're addressing today involving Stephen Kurzinger?
I am.
Okay. So I guess I'd like to direct your attention to June 25th of 2025 at approximately 9:13 p.m. Did Chardon get dispatched regarding a 911 call that was received?
Yes, we did.
Okay, and what was the nature of that 911 call?
The call came in from a neighbor in 300 block of Irma Drive, Chardon Park Estates, that she believed were gunshots. As she looked out her window to investigate what was going on, she looked across the street, 318 Irma Drive. She noticed a body laying on the front porch. She also gave information that she remembers seeing a silver gray vehicle parked in the driveway that was no longer there.
And what did Chardon officers discover when they arrived on scene?
We had two of our officers respond. As they reached the 318 Irma Drive address, they did notice a deceased female, later identified as Alexandria Kurzinger, on the front porch with apparent gunshot wounds to the face. And she is the sole occupant of that residence.
So no one else was in the residence?
No one else, no.
Now, how quickly after receiving that 911 call was the defendant taken into custody?
I want to say it was anywhere between a half hour to 40 minutes.
And where did that occur, and how did that go down?
That occurred actually in Lake County, Concord Township on Ravenna Road. Apparently after the shooting, the defendant went to the Ravenna Road address, made contact with the residents there, a Christina Noonan, and I believe a Nathaniel Woolley lived there as well. They confronted each other out in the driveway there, where at that time Mr. Kurzinger admitted to killing his ex-wife. In turn, Ms. Newman contacted the police department. Sheriff's officers arrived, took Mr. Kurzinger into custody, and secured the gray silver vehicle that he came to the house in.
And then did Chardon officers take custody of him from the family?
Yeah, yes, as they were Chardon and Geauga County deputy officers responded to custody of both the vehicle and him.
Okay. And in looking at in the vehicle, were officers able to find anything of note at that time?
Yes, as they looked in the vehicle, in plain view, they can see a black gun, and it would have been in the driver's door compartment, like a pouch in the door compartment, driver's front door compartment. They also noticed a gun magazine next to that gun, a wallet up closer to where the door handle is, and a loose 9mm round next to that wallet.
And if you could look at the screen, I'm going to show you what's unmarked in State's Exhibit 1 photograph. So what does that photograph depict?
That shows the weapon in the pouch, magazine next to it. If you look above, there's the black wallet with the loose 9mm round.
That would be right around here, correct?
Yes.
Okay. And was the gun processed by BCI?
Yes, it was.
And were they able to determine if this was in fact the gun used in the murder?
That was the gun used in the murder, yes.
Okay. Now, you also mentioned that there's a wallet in that picture. Did you find anything of note in that wallet?
Yes, when we inventoried the wallet, we found the defendant's driver's license in there along with his social security card, numerous credit cards that came back to him. We found some loose cash, I think it was about $3 or $4 in cash, along with some business cards. And we also found a white, looked like a credit card receipt from a Gold Star pawn in Willowick for about, I think it was $288 and some change.
I'm going to show you what we've marked as State's Exhibit 2. Do you recognize that?
Yes, that's the receipt that we found in the wallet.
Okay, and was there a date on the receipt?
It was June, yeah,
If you can read that.
June 13th, 25.
Okay. So that would have been, what, about 12 days prior to the murder?
That's correct, yes.
So, did Chardon follow up at all with Gold Star Pawn to determine what this receipt was for?
Yeah, we followed up with Gold Star Pawn immediately, contacted them. They were able to look up the purchase. We found out that a gun was purchased on that date by the defendant, a 9mm Taurus, I think it's a model G2C handgun, and a box of 9mm ammunition. I believe it's a Blazer brand.
And you said you were able to confirm it. How did you confirm that it was him, in fact, who was in the store?
Well, we got the original receipt. We actually got video from him in the store purchasing the weapon.
Okay, I'm going to show you State's Exhibit 3. Do you recognize that?
Yes, that's a photograph from video that we received of the defendant holding a gun that he purchased.
Now, you mentioned that the gun matched the shooting. You also, though, mentioned that he purchased some ammunition.
Yes.
And the ammunition that he purchased, do you remember how many rounds there were?
It was a 50-round box of ammunition.
Okay. Then, kind of jumping forward in your investigation, but taking into consideration the shells that were located on scene, the bullets in the magazine, the loose round, and then the ammunition you found in the vehicle, were you able to, that all add up to 50 rounds?
That all added up to 50 rounds.
Okay.
Yes, correct.
Now, that night, when the defendant was taken into custody, did Chardon officers receive any information regarding the defendant's movements, either prior to and after the shooting?
Yes.
And first of all, where did that come from?
We actually, during the course of our investigation, we got video from places all around the Chardon area, before, during, and after the incident. We were also able to track his route through a Life 360 app that shows his locations at various times throughout the day.
And Your Honor, in State's Exhibit 4, what we've done is compiled segments of the video that Lieutenant DeLisa has referenced. It's about 60 minutes. I'm not going to play the whole thing. I'll be jumping ahead, but I'll just have him explain what we're seeing and what the video shows. So, Lieutenant, first of all, I note up in the corner we see a date and timestamp of June 25th of 2025, 2058, so that would have been about 8:58, correct?
Correct.
And I'll pause it back. Where is that camera, where's that footage coming from?
That first footage that we showed, yeah, right. That's coming from the residence of Chardon, which is on the northeast corner of Grant Street, Chardon, Windsor, and Southampton Street,
And
facing west.
okay. And in relation to where the murder occurred, where is this?
Kind of hard to see. Up in the middle, you can see a stop sign there, right by that area. That is Irma Drive. The address was 318 Irma Drive, so that's where the vehicle came from.
Okay. And so I'll start playing it, and if you can let us know if you see the defendant's vehicle.
Yeah, right there. And he goes from Irma Drive, stop sign, takes a left, heading westbound on Southampton Street, up towards Charlottesville.
And
Here's the vehicle again, at the top of Chardon Square, continuing heading westbound onto Water Street. That view right there is from the Chardon Fire Department, which is, I think, they're on the northeast corner of the square. This is the second view from the Chardon Fire Department. Vehicle coming up to the stop sign, stopping and then continuing westbound over the top of the square onto Water Street westbound.
and his is this darker silver.
Yeah, the darker gray vehicle.
I'm going to jump ahead a bit. What are we seeing here?
That is Maple Leaf Plaza, specifically Sheets parking lot right there.
Okay, this would be another angle from
That's correct.
Sheets.
Yes.
And this would have been if he just continued straight on the road. He would
Yeah,
have
if you were to
been-
continue straight on to Water Street, this takes you right down to Sheets at the bottom of the hill.
Okay. And is this in fact him again parking?
That is correct, yes.
And what are we seeing here?
You see him walking in the Sheets. He's walking back by the coolers. He eventually takes a right. The top right-hand corner are restrooms, so he goes in the restroom for a while. Doesn't purchase anything.
And then is this him then leaving?
Yeah, exiting,
And it-
past the registers and out the same door he came in.
And it appears he's on a cell phone texting someone at that time.
Yes, that is him. Blue shirt, khaki shorts.
So then this would be him returning to his vehicle after using
Yes.
the bathroom. saw earlier. And then is that him returning?
Yeah, he goes the same route as he went to Sheets, eastbound up Water Street, over the top of the square, back onto South Andrews Street, eastbound, to where he comes up to Irma Drive again, and then turns onto Irma Drive.
And I know it's somewhat blocked by a vehicle here, but we saw it. The
Yes.
vehicle starting to turn.
Yeah, it's he turning in where those other vehicles are.
And that would be in the direction of the victim's residence, correct?
That's correct, yes.
I'm going to pause things here at approximately 21:10 or 9:10 p.m. for a moment. So, Lieutenant, were you also able to obtain the defendant's cell phone
Yes.
during the investigation?
Yes, we were.
And were you able to do an extraction of the cell phone?
Yes.
And did you locate any text messages between him and the victim from that day
We
prior
did.
to the incident?
Yes, we did.
Okay, I'm going to pull it up, and I think you also have a copy in front of you. This is State's Exhibit 5, the text messages. And just to explain it, when the extraction was done, it pulled each text 3 times, correct? So
Yeah, they
it's not that
extracted it
it's
3
sent.
times, so they didn't send 3 of the same text messages.
We're just looking at the text, the column. So outgoing means that he is sending this message, correct?
That's correct.
And if it says incoming, it means he's receiving the message.
Yes,
And these messages were sent to and from the victim's phone.
that's correct.
And the name that he put in there, that would have been the name that he assigned to her.
Exactly.
Okay, and then in the description is the text, the conversation, correct?
That's correct.
Okay, could you read that first text for me?
Yes. Hey, I have a couple things I was wanting to talk to you about, like holidays and such. I was wondering if I could swing by so we could discuss before court, question mark.
Okay, so this reference to court. In the course of your investigation, were you able to determine what he's referring to?
Yes, they had a ongoing custody dispute. I believe it was up in Lake County for the children, visitation, things of that effect.
And were you able to determine when their next court hearing was?
Yes, their next court hearing was supposed to be on the 26th of June, the very next day.
Very next day, okay. And so then the next text, she responds, right, because it's incoming. She's saying she's working, but will be home around 3, and that she has visitation, correct?
Correct.
And then he refers to maybe talking about getting together after visitation, talking about wanting to co-parent better, again, working things out prior to the court hearing, correct?
That's correct.
And then, so you're talking about meeting up, and what does she say about meeting up? You're on number 10.
Yeah, no, she responds back, you can stop over after visitation, but I'm telling you now, you're not allowed any name calling or yelling. He goes, she says, I will walk out, and that there are cameras outside too.
And then she proposes around 7 p.m., it looks like.
That's correct.
And then he responds, what does he suggest?
Yeah, he responds, we can go back, we can go to a park or for a drive. If you feel better about that, I just want to have a plan.
And then he says, no, Christina will be there, no kids, just I'm talking about the kids.
Yes.
And what is her response to his suggestion to leaving the residence?
She just basically says, hey, we can stay in the stay in my driveway.
And he agrees to that.
He
by
agrees,
saying,
yes.
okay. And then these two things, it looks like, would those just be consistent with maybe making a quick phone call to that number?
Yes, yeah, those 2 calls right there.
Okay. And then, at 9:10, these last ones, what does he text her?
At 9:10, I believe this was him coming back from Sheets, that he just texted her back that I'm back. Meaning we're soon back at the residence at 318 room.
So, then, Your Honor, going back to the video, we have the timestamp of 9:10 up in the corner. I'm just going to play this last a couple minutes. just heard some bangs or pops. Were you able to determine what those sounds were?
Those were the two gunshots.
There was about a 3-second
Delay,
pause
yeah,
between
yeah,
the two.
in between the first and the second.
And then eventually, do you see the defendant's vehicle leaving Irma Drive?
Yes. You'll see shortly him leaving Irma, taking a right on the South End, and then he will be taking a left on the Grand Street, coming right in front of the screen.
So we see a black SUV or a black truck.
Yes.
And then right behind it is that his vehicle.
That is the great, yes.
And Lieutenant, the direction he was going, that would have been in the direction ultimately of where he was found at Christina Newman's residence.
That's correct.
All right, so now, going back to the scene of the crime, regarding the victim's body, how many gunshot wounds did she sustain?
There were two gunshot wounds.
And you reviewed the autopsy report. What were the findings? Where were these gunshot wounds located?
There were two to the front of the face. One was on the left side, up by the nasal. I believe they called this the nasal bridge. Entered in through there. When they did the autopsy, they did find a bullet fragment from that round going in.
So there was no exit wound from that?
That's
shot.
correct. No exit wound from that.
How about the second shot?
The second one was in the right cheek area. Went through, exited out the left back, I believe up the scalp area. Yeah, an exit wound. We were unable to locate that round.
And did they make any determinations of whether which one of those caused the death?
They said either one would have been a fatal shot.
Now, while her body was still on scene, were you able to view her body?
Yes, I was.
And did you notice anything regarding the gunshot wound to her right cheek?
I did. When I went up to examine the gunshot wound on the cheek, I found what they call stippling, which is scratching, small scratch marks, burn marks, and they come from the muzzle of the gun. So when the gun is fired, projectiles come out and do kind of like a discoloration, some scratching on the face.
So for that to happen, about how close generally does a gun need to be to a body?
It is a very close range shot. It would have to be close, very close for that to occur.
Now, again, it's been mentioned there's two gunshots that happened, two wounds. Were you able to recover the casings for both of those?
Yes, we were both casings at the scene.
I'm going to show you first State's Exhibit 6. So I know we have a couple placards here. Do you remember where the first casing was found?
The first casing is number 1. It's right out in front of the porch on the front lawn.
Okay. And then where was the second casing found?
You can see the porch on the left. That number 5 is where the second casing was found, directly to the right of the porch.
Okay. And when casings are ejected, can you kind of explain what happens when a casing is ejected from a firearm?
Yeah, sure. They're, when a shot's fired, obviously the round goes out. The case is ejected through a port on the right part of the gun. So when it ejects, it obviously tends to go to the right.
And about how far generally? Is there a
Yeah.
standard line?
Yeah, it can be, a couple feet. It could even be inches as well, so.
And then when the victim's body was removed from the scene, did you find anything of note under where she was laying?
Yeah, the top of the porch, where the victim was found, it's like a composite wood, like Trex decking, a platform on top of the wood. So when they removed the victim in the head area where the gunshots were located, they found what they call a ballistic impact. And it's like a indent or gouge in the Trex decking from a fast-moving projectile when it hits a solid surface. It causes that.
And I'm going to pull up State's Exhibit 8. Is that what this image shows?
Yes, that's correct.
And as you previously mentioned, with the autopsy findings, the gunshot wound to the cheek, there was an exit wound on the back of her head.
Yes, it was.
And would that have been consistent with this ballistic impact?
Yes.
And I think you also mentioned, though, you ended up never finding the actual bullet.
We could not find the round of that. That's correct.
All right. So, Lieutenant, based upon your investigation and everything you've gone through here, were you guys able to put together a belief of how the shooting went down?
Yes.
Could you explain that too?
Yeah, just based upon our investigation, the evidence that we located, obviously help from the medical examiner's office and BCI crime scene investigators. We believe that Mr. Kurzinger came back to 318 Irma Drive approximately at 9:10 that evening, pulled his car in the driveway, exited the car with his 9mm revolver, or pistol, approached the victim, who was on the porch, the front porch at the time. As he got closer, he fired one round, which went in the left side, striking the, the bridge, nasal bridge, which dropped the victim to the ground. He approached closer up to the porch, and at a close range, fired a second round, which went through the cheek, exited out through the back of the head, and then causing that ballistic impact on the Trex decking. Then he entered the vehicle, left the scene, and was eventually arrested at Ravenna Road.
And again, we heard those gunshots that were just before about 9:10 p.m.
Yes.
And the 911 call comes in at 9:13, correct?
That's correct.
And he's out of there pretty much immediately, correct?
Yes.
Thank you. I have nothing further.
Thank you, Mr. DeLisi. You may step down. Officer, Lieutenant. Mr. Burling, any additional evidence, or I guess it's not really evidence, but any additional witnesses?
Mr. Flay, no more witnesses, but Mr. Flays will have a statement.
All right.
Thank you, Your Honor. Just briefly, the state's argument. We often talk about the worst form of the offense, and with aggravated murder, premeditated murder, what is the worst form of the offense? In that situation, how do you differentiate? A life is taken. Here, a mother was murdered at her own home. And the state wanted the court to focus on the aggravating circumstances, what the court just heard from Lieutenant DeLisa and the outstanding investigation that the Chardon Police Department did in this case. You look at the pre-sentence report, the defendant's statement. We had our first decent discussion about 4 years. I wasn't going to go through with it. So that's what his plan was that day, and that's what the evidence shows. 12 days before, he's at the pawn shop purchasing the murder weapon and taking aim in that photo at the counter, thinking about killing her. He lured her into the meeting to talk about their kids. She had a visitation earlier that day, and they had court the very next day. But this defendant had a plan that Alex was never going to make it to that court hearing for her kids. And the defendant executed his plan, and that's exactly what this was, an execution. To direct the court to look at those text messages. He tries to lure her into his car. He tries to get her to go to the park to talk about this. And she was obviously concerned. She says, no, we're doing this in my driveway, and I have cameras. So she's obviously concerned about this. And then he goes there and he has this conversation with her. And then he leaves. And he could have just kept driving. He could have went to Sheetz, used the bathroom, and driven away. But he didn't. He thought about it, got back in his car, he drove back, He texted her, "I'm back," and then he walks up and shoots her in the face. And as she's lying on her doorstep, he walks up to her and at close range shoots her again in the face to make sure that his plan was completed. This was a cold-blooded, premeditated execution of the mother of his children. And the state hopes that the court takes into account the facts and circumstances of this case when fashioning a sentence. Thank you.
Thank you, Mr. Flake. Mr. Bangeter, you reserved any statements or comments that you wanted to make, as well as a statement from Mr. Kurzinger himself. So whenever you're ready, you may proceed.
Thank you, Your Honor. Your Honor, I want to first say that we acknowledge the family who just spoke. Nothing that I'm saying is in response to them. Nothing that I'm saying is attempting to take anything away or minimize any of that grief or loss. Also, the court has heard the state's evidence. I'm not here to dispute that. Not the firearm, the searches, the messages, the videos. Mr. Kurzinger pled guilty to the most serious count in the indictment with no agreement on sentence, exposing himself to every penalty that the law allows. But I want to talk a little bit about the numbers. Obviously, when we talk about life without parole or parole eligibility after 20, 30, 25 years, the reality is every one of those options is a life sentence. Every one of those options say that Stephen is going to spend his life and die in custody of the DRC, unless decades from now the Adult Parole Authority affirmatively finds otherwise based on what happened in the decades intervening. So we're not asking the court to decide when he goes home. We're just asking the court to decide when somebody can ask the question. If the court imposes parole eligibility after 20 years, he's going to be 57. After 25 years, 62, and after 30 years, 67. He'll have spent the remainder of his adult, healthy life in prison regardless. And the parole authority doesn't owe him anything at that time. They can say no. They can say no the first time. They can say no every single time. But they'll be making that decision based on 20, 25, 30 years of evidence that we don't have yet. Life without parole is the finding that a person is beyond the reach of any evidence that hasn't happened yet, any rehabilitation, anything that he does in the next decades. I'm not going to minimize the offense. When we talk about the worst of the offense, and this is the worst kind of offense. But even so, there are different defendants who catch these kind of cases. There is, Stephen he didn't commit this in, of course, another felony to conceal an offense. He didn't do it for money. He didn't do it against a child, an elderly person, a police officer. No captivity, no restraint, no sexual violence, no flight, no concealments, no destroyed evidence, no lie to police, no prior felonies, no prior prison, no community control, nothing. Life without parole is reserved for people who do have that kind of history and do have those kind of factors. And of course, it doesn't make it any less serious for Alexander's family. It's the same seriousness either way. But the question is whether his record is the record that the legislature had in mind when they laid out the possibility of life without the possibility of parole. And I would say that Stephen pled guilty, but the guilty plea, I would say, is often the least reliable evidence of remorse. It's negotiated, it comes with a lawyer, it comes with discussions, and a long court process. But let's look instead what he did right afterwards. Before he had a lawyer, before he was charged, before there was anything at all to gain, he drove to the house where his kids were. He didn't go inside. When his oldest daughter ran out to the car, he told her to get away. He told Christina Newman what he did. He told her to call 911. He did something a person covering up a crime doesn't do. He told her the gun was in the car. He told her where it was. She relayed that to the dispatch. It was already unloaded and left in the door where anyone could see it. When the deputies pulled in, he was already in front of the car, hands already up, complied with every command, completely compliant. He didn't change his clothes, he didn't wipe his hands, he didn't wipe the gun. He asked why not, later why not. He said he didn't want to be accused of tampering with evidence. He was asked why. He told her to call the police, and he said he was not going to run from it. Your Honor, he has been ready and willing to take responsibility for this from the beginning. You know, I know we've gone through some litigation and some court hearings. I point out to the court that he has always been ready to take accountability. All the extra court stuff was me doing my due diligence and making sure his constitutional rights were provided for. This was never going to go to trial. This was never going to be something that he tried to hide from. And I know one of the things we did was we had a sanity report done. We're not here to contest sanity, but mitigation and sanity are different questions. You know, finding that he's legally responsible for what he's done is not the same as finding that he's well. And I think the court is allowed to weigh those factors. We have decades of records from institutions. We have, in the pre-sentence report, mentioned 2 psychiatric hospitalizations as a teenager, 2 more as an adult, both after suicide attempts. We have a history of bipolar, major depression, PTSD, multiple medications over the years, and unfortunately classic situation where a person who's struggling with these things starts to feel better, so they go off the medication and then they crash again, and sort of this cycle that he didn't get off. So again, none of this is an excuse. None of this is to justify anything, but I think it can be used to mitigate that he is not the worst of the worst that life without parole is designed for. He has, since that time, even while incarcerated since that day, he's been completing programs, completing a life skills group, dual diagnosis counseling with EMDR, complying with medications. He's enrolling in mental health groups. He's still trying, even now, even with a life sentence of any sort ahead of him, still trying to come to grips with the mental health and get that fixed. So, Your Honor, obviously he's going to get a life sentence, as I said, either way, but we would ask that he be allowed to apply for parole after 20 years. Thank you.
Thank you, Mr. Banger.
And Your Honor, I know that Mr. Kurzinger does want to say a few words. I just want to mention he did have a whole statement written out, and unfortunately left it back in his cell, so he's going to do his best, but it was originally intended to be much lengthier, I believe.
All right. Mr. Kurzinger, you may proceed with whatever you need to tell me at this point. You could just do it from the table. Thank you.
I just want to apologize to the family and friends. It was not my intent to hurt anybody except for Alexandra. And I'm going to continue to work on myself, better myself, and hopefully become part of society once more.
Thank you, Your Honor.
Thank you. Any other witnesses or evidence, Mr. Banger?
No, Your Honor, thank you.
Any reason why sentence should not be imposed at this time?
No, Your Honor.
Mr. Burling, any reason why sentence should not be imposed at this time?
No, Your Honor.
Court has reviewed the PSI, the plea agreement, and heard the statements of all the witnesses, counsel, and the defendant himself, and reviewed the entire record as available to me. Revised Code 2929.11 provides that the overriding purposes and principles of sentencing are to protect the public from future crime by the defendant or others, to punish the offender, and to promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplishes those purposes without imposing an unnecessary burden on state or local government resources. Sentences must be commensurate with and not demeaning to the seriousness of the offender's conduct and its impact upon the victim, and consistent with sentences imposed for similar crimes committed by similar offenders. To achieve these purposes, the court must consider the incapacitation of the offender, deterring the offender, deterring others, rehabilitating the offender, and restitution. Sentences are not based upon race, ethnic background, gender, or religion. The court must also consider the seriousness and recidivism factors outlined in Revised Code 2929.12, factors indicating whether the offender's conduct is more or less serious and whether or not the offender is more or less likely to commit crimes in the future. We don't see murders in Geauga County but once or twice a decade. So and as Mr. Bangerter points out, my choice is limited. Mr. Kurzinger, you're going to life for prison, or you're going to prison for life. Question is whether or not I'm going to allow you to truncate that by applying for parole. I am essentially imposing the most serious penalty I can under the law solely within my discretion without the recommendation of a jury. On the other hand, you committed the worst crime that society has. You took the life of another human being. Not in self-defense, not in a fit of rage, but with prior calculation and design. You purchased a firearm, you took it with you, you lay in wait, and you shot her in the face. Presumably, she saw you coming, and she knew it was going to happen. She knew she was about to die. Mr. Bangerter points out you didn't run, you didn't attempt to conceal your act, you submitted to police officers, in my opinion, indicating you knew what you did. You knew what you were going to do, you had planned it out, you knew you committed a cold-blooded murder. Alexandria was working to better herself, by all accounts. She was making efforts to right her ship, become a productive member of society again, attempting to become a better mother for her and your children. You took that away. Mr. Bangerter and the prosecutor have both, used the word worst version of the offense, or that term. And while if we were in downtown Cleveland, maybe that were true. In Geauga County, the offense itself is the worst version of the offense. This doesn't happen here. And it shouldn't happen here. And as a result of all of those factors and what I have heard today, I am going to sentence you for count 1 of the indictment, aggravated murder and unclassified felony, to life in prison without the possibility of parole. You will be ordered to forfeit the firearm used in the offense, a Taurus handgun. I will not impose a fine. You have served 407 days in the Geauga County Jail to this point, and at the state's request, I will be dismissing counts 2 and 3 of the indictment. You will be ordered to pay court costs. If you fail to pay any financial penalty or cost, I may order you to perform up to 40 hours a month community service, which will not happen in this case. And I will issue judgment for the costs for which execution may issue. You do have the right to appeal or seek leave to appeal the sentence I have imposed. If you're unable to pay the cost of an appeal, you have the right to appeal without payment. If you're unable to obtain counsel for an appeal, counsel will be appointed to you without cost. If you're unable to pay the costs of documents necessary for an appeal, the documents will be provided without cost. You have the right to have a notice of appeal timely filed on your behalf. Mr. Burling.
Just Your Honor, regarding the dismissal, also dismissal of the first specification.
Okay. What was that specification?
That was the firearms packet.
All right, so we will also be dismissing the firearm specification for count 1, correct?
Correct.
Anything else?
No, Your Honor.
Mr. Banger, anything?
Your Honor, we'd ask the court to appoint counsel for appeal.
Okay, I would prefer that you file a motion in writing, please.
Certainly.
But we will certainly appoint counsel for an appeal. If nothing else, we are adjourned. I am going to ask, you'll be given instructions on how to exit the courtroom, please. So everybody remain seated until instructed by the deputies or the bailiffs. Thank you.
All rise.